You're a good negotiator. You love a good argument. You know your case better than anyone. And now your case is coming up for trial, and you decide you want to make opening arguments in your own trial. Can you do it? Should you do it? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Do I think it's a good idea? No, I don't. I think it's a terrible idea. Could you do it? The answer is you actually could. How? Because you can actually represent yourself. In that instance, you'd be the one making opening arguments to the jury. But keep in mind, when you make opening arguments, you have to know not just the facts of the case, you have to know the law in the case. Because if you don't set forth what's known as a prima facie case, which means if you don't set forth the elements needed to show that you are entitled to verdict, guess what? Before the defense attorney stands up to make his opening arguments, he can ask the judge to dismiss your case, claiming that you haven't set forth that you're entitled to a verdict in your favor. That's failing to make out a prima facie case, failing to show that there was liability or wrongdoing, failing to show that that wrongdoing was a cause of your injury. There has to be a connection, a bridge between the wrongdoing and your injury, and failing to show that your injuries are significant and permanent. And that can happen just in opening arguments. So if you fail to address the law and how the facts are connected to the issues in your favor, there is the possibility that the defense will ask the judge to throw your case out before he ever stands up to make his own opening remarks. And you know what? If you haven't made out a case, or if you haven't shown that you're going to prove that you have a valid case, the judge will have no choice but to dismiss your case. Then before any evidence is presented, before any witnesses get to testify, your case is done and finished. So to go back to the original question, even though you want to make opening arguments, even though you think you're going to make great opening arguments, my best suggestion is let your experienced attorney handle it for you. So why do I share this great information with you? I share it with you because, in all likelihood, you have that urge, that desire to go ahead and try and make opening arguments yourself, or at least raise the possibility of that with your attorney. Is it a good idea? Absolutely not. Should you do it? In my opinion, definitely not. You know, I recognize you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.